Your Honor, he is admitting that. He's admitting
That what?
that he had a mixed drink on that day.
Why didn't you just tell community corrections center?
Your Honor, I believe my client wanted the opportunity to just go and take care of it. He started doing everything he could. Like I told you, he has proof of AA. He has proof of him taking care of his sobriety. I think in that moment, he just he didn't want to have to go back to jail. He wanted to put steps in place so that he perhaps didn't have to go to jail as a result of that violation.
I didn't have any intention of drinking. I didn't realize there was alcohol in the house. I woke up in the middle of the night, I drank something, you couldn't undrink it
You realize there was alcohol where?
in my house. Anyway,
Your Honor, he just, when he spoke to me about it, he said he made a very bad mistake. He understood his mistake. He's been trying to fix that day. So he is going to admit that he did have a drink that day.
What's he been doing since the 20th to try to resolve it?
Good morning, Your Honor. Ashley Hannibal requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Stephanie Cannon.
Permission to practice is granted.
All right. On behalf of Mr. Bunch. Can you your name?
Paul.
Received it.
Okay. All right. You're requesting, or not?
Yes, Your Honor.
All right. I will adjourn the matter. I'll adjourn it to the 20th. However, we have a bond violation court. Are you aware?
I was not, no.
Well, it's the July 20th. A positive alcohol test. And then a series where he did not retest.
Sorry, Your Honor, Stephanie Cannon on behalf of Mr.
Bunch.
Bunch. Your Honor, I was unaware of those allegations. My client, of course,
July 20th, 2026 at 6 a.m. Mr. Bunch submitted a positive test with a blood alcohol content of 0.035. On that same date, at 6:23 a.m., he submitted another positive test, 0.034. And 6:47 a.m. blood alcohol content of 0.032, and at 7:14 that same day, blood alcohol content of 0.024. On that same day, as pursuant to what the program that he's in the testing, he was to submit to scheduled retest. He failed to do so on that same date at 7:29, 7:59, and 8:29. Did not retest.
have you been testing since then?
Yeah, it didn't tell me to read it.
Thank you, Your Honor. My client is aware of the allegations against him. Are we arraigning him on this, Your Honor, at the moment, or just letting me know what's happening?
Well, he happened to show up before there was a warrant that was signed.
Okay.
So it was going to be a no bond warrant, but
Thank you, Your Honor. I've spoken to my client regarding, he's heard that, he's been talking to me. It's my understanding that since then, he has not been testing positive. He is going to AA, he has a sponsor. He's not going to tell the court that he has not or had not struggled with his sobriety up until then. But as a result, he has taken every step he can possibly take to remain sober. He has his AA paperwork with him today.
he admitting to these or not?
The 7/21.
Because here's what he told community corrections. They contacted him on that same date. He denied consuming alcohol
Your Honor,
and then stated it must have been his mouthwash.
Your Honor,
I haven't heard that one in a minute.
yeah,
But yeah, because that takes a pretty
Hey.
powerful mouthwash to last that long.
in talking to my client, that is not what he told me when he talked to me about it. He was very truthful
Okay.
and forthcoming, and he's not going to tell the court anything different. than what he told me regarding that particular incident, that situation. As a direct result of that, though, he did take every step possible that he could take to make a sobriety. He started going to AA. He started working with a counselor. He's been doing everything he could as it relates to that, Your Honor. So he is. Are you going to admit to that drinking incident? You need to be truthful. Did you drink?
Believe I did.
Yes, Your Honor. He is admitting that. He's admitting
That what?
that he had a mixed drink on that day.
Why didn't you just tell community corrections center?
Your Honor, I believe my client wanted the opportunity to just go and take care of it. He started doing everything he could. Like I told you, he has proof of AA. He has proof of him taking care of his sobriety. I think in that moment, he just he didn't want to have to go back to jail. He wanted to put steps in place so that he perhaps didn't have to go to jail as a result of that violation.
I didn't have any intention of drinking. I didn't realize there was alcohol in the house. I woke up in the middle of the night, I drank something, you couldn't undrink it
You realize there was alcohol where?
in my house. Anyway,
Your Honor, he just, when he spoke to me about it, he said he made a very bad mistake. He understood his mistake. He's been trying to fix that day. So he is going to admit that he did have a drink that day.
What's he been doing since the 20th to try to resolve it?
Yes, his AA paperwork. Yes,
Wasn't he at
Tim,
that before?
were you attending AA before?
yes.
He has his AA paperwork.
So what's he done different given this event?
Oh yeah. He's been working with his sobriety coach intently, Your Honor. He tells me that since that incident, he has not had anything to drink. It indicated that it really was almost reflex because he has been drinking for that long. He admits that it was almost like just a reflex, and once it happened, he knew he couldn't fix it, so he called his sponsor. He's been working as best he can to maintain his sobriety since that incident.
Mr. Cook.
Your Honor, people are going to be asking for remand with potential consideration of release to treatment down the line. But I have some suggestions for this defendant and that it seems to me he has an alcohol problem, and that problem is winning. And I don't think that if he's released, he can on his own get the treatment needed to help him work on this. My concerns arise both from the history of this defendant, the underlying facts or allegations of this case, as well as some statements that have been made, specifically as it relates to the defense prior history. He has a prior operating while intoxicated second, as well as allowing an intoxicated individual to drive. In this case, the report indicates he was a .377 when he punched an officer in the face. And then I also have concerns because looking at the notes from arraignment, it indicates our office had initially requested a scram tether. The defendant at that time indicated that wouldn't work for him because he worked with, I think it was cleaning alcohol for cleaning. So a scram would be appropriate. We then get the report that tests positive for alcohol. He says it was mouthwash. Now we're hearing today that he thinks it was something he didn't know had alcohol in it. That sounds to me like excuses to allow him to drink. And I think that I don't think he wants to be drinking, but I don't think he can be trusted on his own not to drink. So I believe remand is necessary for his own betterment,
Get you
in this case, as well as for public safety and compliance.
It's about the best thing to be able to do at this point. Let's get you treatment.
Get my lost bench.
Your Honor, if the court is inclined to remand him today, I would ask that he be allowed to be released to treatment as well. My client is not arguing that he is not struggling. He wasn't drinking at the time of this. I'm sorry, he wasn't driving at the time of his recent incident. The one that brings him before the court to let the court know that he was at a restaurant trying to get something to eat and the police were called, but he is struggling. He's not denying it. He's not going to deny it to you. He's not going to deny it to anyone. It's just, it's an addiction that is socially acceptable at times. And he is struggling, Your Honor.
Turn this to the 20th. I will potentially allow release to inpatient treatment if you
I'll get you in order, Your Honor.
order. That would have to be with the GPS tether. So I'm adjourning it to the 20th. I'll sign that order. And at this point, I don't think you know what you really want to say, because Mr. Cook is right. Everything that you're saying is making excuses. And frankly, that's what alcoholics do, particularly when they're caught. You just keep making excuses. So you have to make a determination as to really whether or not you want to deal with this or not. But you'll have time to think about it. Defendant's bond is revoked. Andrew.
Thank you, Your Honor. I'm gonna get this back.
Thank you, Attorney.
Welcome, sir. Is it? Seriously? Court calls case, People versus Jeremiah Young.
Assistant Public Defender Emzo Hutchins on behalf of Mr. Young, who is approaching. Mr. Young, please state your name for the record.
Jeremiah Young.
Thank you, Your Honor. We would be requesting an adjournment for further discovery.
That discovery is voluminous, and that it is 101 films. The defendant made to the victim's number exclusively after being arraigned and told not to have contact with her. I've not had a chance to review those calls today or tomorrow. And for at this time, his bond to be revoked along with his phone and texting privileges. This is an extremely serious domestic violence case involving strangulation to the point of urination. The defendant telling me that he killed her. She tried to get help. I do believe at some point this could even potentially have an AWIM added to it at exam, given the facts of this case. So this is going to be estimates bond be revoked for the 101 jail calls he made exclusively after being arraigned, and then his phone and text be revoked as well.
Thank you, Your Honor. His bond, I believe, is already set at 75,000 cash or surety. And which I feel for this
7 or 2? 7. Okay.
which is already incredibly high and could be $1 million, and it wouldn't really matter at this point. As for his phone privileges, we would just ask the court to ask the jail to block that number. And then that problem is solved, but he can still communicate with his family with regards to this case moving forward.
I'll adjourn this out to August 27th, 2026, 9 a.m. Defendant's phone privileges and texting privileges are hereby ordered revoked. I would also, given the number of calls to specifically the victim in this case, I think it's appropriate that this defendant bond be revoked. So his bond is also revoked. Thank you.
Thank you, Your Honor.
So what are all these?
Out of custody and its facilities that.
So like that out of custody are still here.
Yes, sir.
Okay.
Yes, and that's the rest of the one.
Court calls case, the People versus E.B. Henga.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Kinga. Your Honor, Mr. Kinga changed his number, got a new number. We didn't have,
State your
oh,
name.
I'm sorry.
Stevie Kinga.
Thank you.
We were unable to connect before today's date. He did give me an updated number, so
Have an updated number now.
yes.
You're asking for an adjournment?
Yes, please.
Turn it to August 27th, 2026, 9.
Thank you.
Thank you.
Thank you.
Court calls case of the People versus Jonathan Carey.
Assistant Public Defender Jay Bellinger on behalf of Mr. Carey, who's an appearance via Zoom, Your Honor.
Sorry, what? No, I got it.
Mr. Carey, can you please state your name for the record?
Yeah, Jonathan Carey.
All All right, what are we doing?
Your Honor, at this time, we're asking to set this matter for preliminary examination. All discovery is complete from our understanding.
People have their witnesses available the 18th. Preliminary examination, August 18th, 2026, 9 a.m. That's before judge. Before me.
Thank
Thank you, Your Honor.
Thank you. Court does call the case of People versus Tommy Lee Clark Jr.
Stephanie Kane, on behalf of Mr. Clark, Your Honor, who is appearing by Zoom. Your Honor, at this time, we are asking for an adjournment for investigative and mitigation purposes. I am trying to prepare a motion on his behalf, as the court is aware. I see a little bit more time on it.
Your name, sir? I'll adjourn it to September 3rd, 2026, 9 a.m. Bond continued.
Excuse me, Mr. Simpson.
Yes, sir.
Just trying to see, am I able to get the testing moved? Because I'm currently going to be on probation through another Monday.
I can't make out what you're telling me, sir.
Mr. Clark, your signal is really bad. You're actually frozen and we can't hear what you're saying.
Oh, sorry. Can you hear it now? Hi. Is that fine?
Yeah, I can hear you. Go ahead. Try again.
Okay. I'm currently about to be on probation through Oakland County on Monday, and I was trying to see, can I be excused from going through this testing since I'm going to be testing with them?
Well,
We have results from them, Your Honor.
but you're not on probation with them yet.
Well, I will be this coming Monday. Yeah.
Hey, but after we see what the order is, then I can take a look at it. I can't answer it in a vacuum like that, sir.
Mr. Clark, you have my information. Call me on Tuesday and I will submit a request to the court, but you have to call me so I can submit the request, okay?
All right.
Thank you.
All right.
Court calls the cases of the People versus Danina Combs.
And Assistant Public Defender Nick Buckovich on behalf of Ms. Combs, who should be appearing via Zoom.
Ms. Combs? That may be her.
So I believe that is, so she's.
Can you hear me?
State your name.
Go to the phone and unmute. Danina.
Is that her? Okay. What are we doing?
At this time, Your Honor, I will be requesting an adjournment. We're looking into some other forms of resolution that may include looking into outer county sobriety court. So I would ask for a slightly longer adjournment because I need a time to be able
To try to find. Adjourn it to September 3rd,
I appreciate that, Your Honor.
2026, 9 a.m. Thank you.
You're done.
Thank you, ma'am. September 3rd.
Okay, thanks, Judge Simpson.
You're welcome. Court calls the case People versus Malik.
She's gonna leave here. Okay. You can't. They won't let you. Oh.
You, Mr. Cook?
Come on, Mr. Cook. All right, Judge.
That wasn't your fault. Creature got in the way.
That's
Nick.
right.
Malik.
Judge is setting this matter for preliminary exam.
Got all discovered.
To our knowledge, Judge, yes.
Are there witnesses available the 18th? Preliminary examination, August 18th, 2026, 9 a.m. for Judge Moore.
Yeah.
Thank you.
Same building.
Thank you, sir.
Thank you, Judge.
Okay.
Oh. Extra meat. Court calls case People versus John Costello.
Assistant Public Defender Jay Bellinger on behalf of, with Mr. Costello. Your Honor, my understanding is that there was a no bond warrant that was issued, I believe yesterday before on this matter. Mr. Costello did come into our office. I was able to speak with him on the At that time, that was yesterday. We did,
I issued a warrant yesterday.
it was either yesterday, I believe.
Yes, I did.
We gave him bus fare to be here. Unfortunately, I don't see him here today at this point.
So what I will do is I will leave the current warrant outstanding.
Thank you.
Court calls case People versus Kentria Cummings.
Possibly Michigan on behalf of Kentaria Cummings.
Your name, ma'am?
Kentaria Cummings.
Thank you.
Your Honor, we are requesting a 4-week adjournment. We have put in a referral to the AIM division in our office just to see if a resolution is possible at this.
August 27th, 2026, 9 a.m. bond continues.
Thank you, Your Honor.
Thank you.
Court calls case People versus Richard Curry.
Good afternoon, Your Honor. Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Curry. Say your name, please, sir.
Richard Curry.
He'll explain to him about the dress code, I presume.
Yes, Your Honor. So Mr. Curry and I were unable to speak. He did give me updated contact information today. There's some investigations we are looking into, and Mr. Curry is also considering retaining counsel. So we're asking for an adjournment.
How much time would he need to retain counsel? I mean,
Kind of depends on, I think, how the investigation goes. Is that fair? So,
Realistically, if I'm gonna hire an attorney.
okay.
Yeah.
So we'll just ask for the next available date, Your Honor. I think.
August 27th, 2026, 9 a.m.
Thank you, Judge.
Court calls case People versus Evan LeBron.
Assistant Public Defender Jay Vaughn on behalf of Mr. LeBron, who approaches. State your name for the record.
Evan LeBron.
Your Honor, we just got the discovery for this yesterday. I'm just asking for a brief adjournment.
27th. August 27th, 2026, 9 a.m. Thank you.
Thank you. We'll be in touch, okay?
Okay.
We'll be, yeah, fun stuff. All right, you bet.
Court calls the case the People versus Amber Dunson. This facility did not sign in Oakland County.
That's, Raymond
Pardon?
Raymond Cook for the people. Dunson.
They did not confirm the writ, so I'll adjourn this out to 27th of August. Court calls the case of the People versus Saquon McKinney. Wayne County Jail did not confirm or did not sign in with this person.
to another facility, so.
So he's someplace else right now.
In Oakland now, Your Honor, yeah.
Oakland.
I saw him last week.
All right. So what I will do is I will adjourn that out to September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Court does call the case of the People versus Mamadou Diallo.
And with that, just on behalf of Mr. Diallo.
And were you able,
So he was transferred. I was able to talk to someone from the jail. I explained to them the time difference. They were supposed to sign in. I don't know why they didn't. I was not able to meet with him, but
I have to give this federal question, I have to give them once.
I did clarify, we can do
I don't know
that.
if he needs to.
We can, 3 weeks? Okay. Probable cause conference, I'll adjourn this out into the 27th.
Thank you.
Court does call the case of the People versus Stephen Givan.
Good afternoon, Raymond Cook.
Some Public Defender Jay Vaughn on behalf of Mr. Given.
I'm sorry. This is a forensic center case and they did not sign it. Did not sign in. I'll adjourn this out September 3rd.
Thank you, Your Honor.
That'll be adjourned to September 3rd, 2020. Court does call the case People versus Antonio Williams. This is also a forensic case. They did not sign in. I'll adjourn that one also out to September 3rd, 2026. Is that it? Finally. Court's going to take a recess. Those of you on my 12:30 call be a little bit behind, but we'll get out of here before I start that one. What do you say?
Sorry, 4:45 for so many people.
Trying to set my schedule? Oh, you're trying to set their schedule. Oh, you want them to eat?
They're a lot nicer.
No, really not. Not cooked.
Okay.
In fact, we have a rule here, do not feed cook.
Oh, very good.
Because it's really ugly. It's like a gremlin. All right, so anyway, what I will do, court is standing recess, that'd be fine. About that time.
Arise.
Yeah.
Yeah, thank you.
You're welcome. Court calls the case People versus Sharita AG.
Morning, Your Honor. I'm So Hutchins, Assistant Public Defender on behalf of Charita Aggie, who is standing to my right.
Take your hands out of your pockets. Name?
Sharita AG.
Sharif. I messed.
It's okay. You can read it if it's more simple.
What do you say?
You can call me Rita if it's more simple.
Rita? Oh, hey, Rita, what's up?
Hi.
All right. Okay, what are we doing?
Thank you, Your Honor. We are requesting an adjournment for further negotiation.
Probable cause conference will be adjourned September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Andrew Party.
Next fellows from people.
Carolyn Foster Tucker on behalf of Andrew Party.
You know, these guys in lockup transport, they do a fantastic job till they're interfered with. Go ahead.
Sorry.
Party. Thank you, sir.
Your Honor, we are requesting a preliminary exam in this matter, and if I may briefly address bond,
Discovery is complete.
to my knowledge.
No other witnesses available the 18th.
Your Honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. That is before Judge Moore. Esteban.
Your Honor, Mr. Party is asking if the court would consider a release to treatment. I don't believe that there's an objection from the people. If the courts would consider that, I can do a stipulated order.
Objection from the people.
Looks like there was an MTA in December, but I'm fine. I'll leave it in your discretion.
All right. I will sign an order for release to treatment with, but he'll have to be on a tether.
Okay.
If you prepare the order, I'll sign off on it.
Okay. Thank you.
All right. Thank you. Court calls case People versus Dion Bird.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Bird, who is present via Zoom. Sir, can you please state your name?
Yeah, Amber.
Go ahead.
Your Honor, we would set this matter for exam.
And discovery is complete.
To our knowledge.
Discovery is complete as it relates to the current charges. Started off as an OWI investigation. We don't yet have the blood back from that OWI, but that would be a misdemeanor that wouldn't necessarily need to be addressed at exam. So we should be able to proceed without that.
All right. Set preliminary examination August 18th, 2026, 9 a.m. before Judge.
For you.
For me.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Joseph AG.
That's spelled.
Ashley Bashir on behalf of Joseph Agee. Mr. Agee is on Zoom. Mr. Agee, if you could say your full name.
My name is Joseph Agee.
Or Agee. Your Honor, we're requesting a brief adjournment, for further negotiations on this matter. Possible. Sorry,
Preliminary probable cause conference will be
these
August,
aren't all.
August 27th, 2020. 9 a.m. On continue. Thank you, sir.
Thank you, Judge Simpson.
Court calls case People versus Linnell Wall.
Okay.
Hey, good morning, Your Honor. Terry Johnson on behalf of Mr. Linnell Wall.
Yep.
Go on to state your name. This is for me. Thank you. Just state your name for the Linnell Wall.
All right. All right. What are we doing?
Thank you, Your Honor. We are in receipt of the competency results. I've had an opportunity to speak with my client. We would like to request an independent evaluation.
Okay.
And we have that set up. Obviously, we just need the approval of the court, and I will be submitting an order as well.
But I will allow an independent evaluation that is self-financed. Because
Yes, I understand, Your Honor. Yes.
All right.
Mr. Johnson did inform me that he had, I believe, an expert already ready to go, just in the court's order.
Oh,
correct.
So if you prepare an order, I'll sign off on it.
That's fine. Can I submit it to your staff, Your Honor, electronically, or?
Try to get it to me and I'm not going to sign it. Yeah, you better get it to them. Yeah, just
No problem, Your Honor.
send it to Ms. Weidling. It'll get to me and I'll sign off.
Sounds good, Your Honor.
All right.
And Your Honor, I'm sorry.
Go ahead. And how much time then for that to occur, a report, and there's going to have to be time for the prosecutor to review that report.
45 days? 45 days, Your Honor?
So I'll set a competency hearing. Here's what I'll do. I'll set it for September 17th. If counsel could let me know after receiving that it's going to go forth, because I'll have to move it to a date that we're clear to hear testimony.
Understand, Your Honor.
Okay. So I'll adjourn his competency hearing date to September 17th, 2026, 9 a.m.
Thank you, Your Honor.
All right.
That's in the middle of football season, or it's the start of football season.
I went to Maryland, so we don't pay attention.
I'm sorry?
Nothing. Yes, it is.
I'm sorry?
It is in the middle. I said I went to Maryland.
No, I heard you say you went to Maryland. That's what I was sorry about, Your Honor. Just. You might be fine, Bob.
Take it. No, wow. That's outright attack. I was actually being mellow about it. Attack me. Just attack.
That was from Mr. Mikowski, just so the record's clear. So you know who to go after.
I shoot the messenger. Then I don't have a problem with that. All right.
Thank you.
Thank
you. See you.
Take care. All right. Oh, my little turtle feelings are hurt. Court calls the case. People versus Jamie Alexander.
Here, I'm Jamie Alexander, very sorry.
No, it's okay. Who was over there bothering you? Davi.
No, it was,
Oh, yes, it's his fault.
I'm
not blaming you. It's Davi's fault. He'll take it. All right, what are we doing?
Apologize, Your Honor. Unfortunately, I have not been able to reach Miss Alexander. She does not have a working phone number, and I've requested.
Not in, right?
Yeah.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Here. Court calls the case. People versus Nicholas Coots.
Herman Judge on behalf of Mr. Hood. Can you please state your name for the record?
Both Coots. Thank you, sir.
Your Honor, we have just completed the mitigation process. We did send the packet to the prosecutor yesterday. I believe there is understandably time needed to review that. So I'd ask for a shorter adjournment so that we can resolve this case.
Want the 20th? Will that work? Or you want the 27th? The 20th? Probable cause conference will be adjourned August 20th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. All right. So how many more custodies do this is taking forever?
It was seen for I've got about.
I mean, it's not their fault. I just got 15 and you got these. Court does call the case, People versus John Andressen. But I may throw them into.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Andresen. Will you state your name for the record?
John Andreessen, Your Honor.
Andresen.
Where are his pants?
We'll have them next time.
What? Where's
We'll have them next time.
They're not all here.
It's hot out.
No, really, it's not.
It's like humid. Hot and humid? Humid, yeah. Anne agrees. Judge, I did submit a referral for a request to do some mitigation in this case. So if we could have a little bit longer of an adjournment so I can prepare that information.
Probable cause conference. So I'll have long pants. I'll go into the fall, September 3rd, 2026, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor. Let's go with golfing. And I have no idea what to do with that. Court calls the case People versus Mario Crawford.
People.
Do we have the
Crawford. Stephanie Cameron.
Mario Crawford, Your Honor.
Your Honor, we actually have received plea paperwork in this case. I'm going to ask for an adjournment so that the police can.
What?
What?
That was a lot. Was it clear to you?
Was it?
No.
Was I?
No. Was it clear to you?
She wants Crawford. Was it clear?
I pretty much think it was.
What?
Your Honor, we have reached a plea deal in this case. I'm asking for an adjournment so that the paperwork can be submitted.
Did you get that, Mr. Crump?
Yes, sir. I did, Your Honor.
You understood it?
Yes, I did.
I had no idea. She could have been talking French to me.
I got no French. I got no French.
What?
We have English under control, Your Honor. So
I know that.
just so we just need a brief adjournment so we can get a plea.
13.
And
1 week will do.
1 week will do fine, Your Honor. Yes. Can I address bond in this case? So my client has been picked up for the tether going below 20%. He had been hospitalized, and we have the paperwork showing the hospitalization. He had been hospitalized. I believe I forwarded it to the prosecutor. I did not forward it to the court. I'm sorry. During that process, when he was let out, in his belongings, the charger thing wasn't there. He called his office, his agent, and let them know about it, and said he would be coming into community corrections first thing in the morning to charge it. But they came that night and picked him up. So the paperwork, and the agent knew this, that he was in the hospital. They knew this, that they had the conversation. The day he was released, gets home, he can't find the charging cord. He called, told them this, and said, I'll be in first thing in the morning to charge it. And so he was very surprised when the agent picked him up, because they had just spoken like 40 minutes before, where he explained that he was released from the hospital and the charger was not in his belongings anymore. Your Honor, my client is asking me if he'd be really fine with being on tether. He was doing good on tether before he went into the hospital. He's asking to be released on GPS tether again. I think it's yours, right?
Response.
Only thing that I would add is I do see the defendant failed to appear, I believe, on May 21st, and there was a bench warrant issued on that date. If the court, I recognize we've reached a resolution on this, and part of that was because of the treatment documentation that I received. So I do agree that it looks like the defendant is in a better place than where he was before. Ultimately, I would leave it.
And Your Honor, as to that date, he wound up doing a bench warrant recall. It's my understanding he got the timing wrong. So he called immediately once we communicated, and he was like, I thought it was at this time, not this time. And so he took care of that immediately, or as quickly as he could based on the circumstances.
Anything else?
No, Your Honor, we just wanted to put that out there.
I'll grant the motion. I will release him, his previous bond is reinstated with the GPS tether.
Thank you, Your Honor.
Welcome.
Here is so.
Oh, don't fist bump. She didn't do anything. I did it.
Thank you, Your Honor. Thank you, Your Honor.
No, I saw that. No, go. Go. Absolutely nothing.
Monday, correct? Or I'm sorry, next Thursday?
Yes.
I just wanted him to hear it again, because he got excited.
Yes.
I just really liked it. Thank you, Judge. Go Turks.
Court calls the case, People versus Rico Tuso.
Assistant Public Defender Zach Venue, on behalf of Mr. Artuso and possibly with.
Sure. Leave it alone. But just, what? Why are you coming? Record should reflect we've had a bench conference in this case. I will adjourn this to August 27th, 2029.
Thank you, Your Honor.
Thank you. Pardon? 27. Court calls case People versus Jason Wilson.
And now we have.
Ready, Your Honor.
Good morning, I'm Rob Dico on behalf of Mr. Wilson. Mr. Wilson, would you state your name for the record?
Jason Wilson.
Can we set exams in these matters?
Sure. Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 18th. Set preliminary examination of both matters for August 18th, 2020, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case People versus Faith Askew.
Thank you, for the people, Your Honor.
I'm so Hutchins, Assistant Public Defender for Faith Askew, who I believe is appearing on Zoom. Ms. Askew, please unmute your microphone, show your camera and state your name for the record.
Faith Askew.
Better. You may. Record should reflect we've had a bench conference in this case. Miss Askew,
Yes.
I am going to order that you appear in person. I'll need you here at the courthouse later today.
Okay. I'm not sure if I can make it because I don't have transportation. I'm in Detroit.
Hey, so Miss Askew,
Yes.
I'm going to let you come down here voluntarily. Otherwise, we will send people and solve that transportation problem.
Okay.
So what time can you be here?
I'm not sure, but I don't know. I could figure something out.
Okay, so here's what I'm going to do. You need to be at the courthouse by 2:00. If you're not here by 2:00 in that call, I'll be issuing a warrant.
Okay.
Fair enough?
Yeah. Is it
All right.
possible?
Thank you.
Excuse me.
Yes, ma'am.
Is it possible if somebody could come get me? Because I'm not sure if I could get transportation.
I don't think you want the people that I'd send to come get you.
Okay, thank you, Judge.
Her mother's present? I got you.
Mother's present.
So I need you here by 2:00.
Okay.
Thank you. Thank you, ma'am.
Have a good day.
Thank you, you too. Court calls the case People versus Fabian Housemer. Who is that?
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Hosmer. State your name for the record, please.
Brianne Hosmer.
Thank you.
Your Honor, we're requesting an adjournment. I spoke with Ms. Dover. She just needs a little bit more time for a potential offer. And Ms. Hosmer is requesting a reduction of bond.
Okay. So how much time do you need for the adjournment?
I said just a couple of weeks, Ms. Dover.
The 20th
Sure,
at 9 a.m.
sure.
All right. And then Esteban.
Your Honor, Ms. Hosmer is requesting a personal bond. She stated that at least one or two of her previous failure to appears were because of lack of transportation. If she got out, she does have a stable place to live now with her parents, as well as reliable transportation.
What city is that in?
Manchester. Her dad could drive her, or a family friend, I believe you said.
Yes.
She also does have stable employment. She cleans houses and does other side jobs. So we're asking for your consideration.
Response from the people.
You see that the defendant has failed both hearings previous, that would be my concern.
Where were you when you failed to appear? Where were you living then?
I was in Columbia Township. I was in Jackson. Here's what I was going to ask, Your Honor. They pulled me over. They also pulled up on me the Saturday before Easter and said that they wouldn't bring me out here.
Who?
The Columbia Township Police Department.
So I told her that Your Honor may ask, well, what warrant status, what have you been doing? She said that she has been stopped multiple times and they told her they wouldn't take her in for a nonviolent felony. That she interpreted that to mean she shouldn't turn herself in on the warrant because they
said they weren't accepting nonviolent offenders.
Oh, we take all kinds of.
Well, I'm not sure.
That's why you're here. See, that was wrong.
Michigan State Police picked me up.
Pardon?
The state police picked me up and brought me here.
They'll take them too.
Right.
So, and then you're here.
I'm here. Hi.
So, Michigan State Police picked you up because why?
From Jackson County.
Jail.
Yes. Unlicensed dogs in Columbia Township. That's 3 years old. Unlicensed dogs, 3 dogs, animal control killed one. So I only have 2 and they're not even in my possession.
That's why you were in Jackson County Jail or Columbia.
Yeah, that's why they picked me up initially. Yeah. Unlicensed dogs in Columbia Township, $1,000 piece.
Okay, so from that, you ended up in jail?
Yes, Your Honor, and Michigan State Police came and picked me up. They said I had a state hold for this. Let me ride in the front. All the way here, whatever.
It was nice of them.
And it was very nice.
So you see anything? So she had unlicensed, here's what I get. She had unlicensed dogs. One of the dogs got shot.
The animal control killed one.
Okay.
Yeah.
So one of the dogs isn't with us. She goes to jail. Why'd you go to jail?
I had a warrant for failure to appear for unlicensed dogs in Columbia Township. Like 6 of them. I didn't even know. I had a lawyer. I got picked up on a PPO violation 2 years ago. And they kept me in jail because of the unlicensed dog charge. I had to see a lawyer.
What? Don't try to blame Judge Washington for anything, my good friend. No, Judge Washington does not do that. Other people do that.
So I had a lawyer for the case. I thought the lawyer took care of it. Haven't had the dogs. It's just whatever.
So stay with me here. So why were you dealing with the police at all for them to take you in for the unlicensed dogs?
So my boyfriend, I thought he had my phone. Okay. His mom called the police on me because we were verbally arguing. He was in his shed. I was in my.
Hang it. Go ahead.
I was in the shed, or he was in his shed.
Stop there. So called the police.
Yeah.
Okay.
She called the police.
Okay.
Police contact, and she's like, "Oh, I have to take you in on your warrants." But okay, cool. I need a vacation. Well, I didn't think I was going to be here this long, but it's been a vacation. And now I just want to go home. It's ridiculous. I'm sorry.
Response.
I do not see any out of county polls currently. So I have nothing to add towards the jail.
Why do I get a feeling that if I let you go, it's going to be a long process to get you back here?
I have court on August 27th in Jackson County. I don't think it'd be a long process.
What?
The dogs.
That the dog thing was over.
It's not over.
They reduced your bond and let you out.
They let me out. And I thought I was coming home, and the state police were like, "Oh, Miss Hosmer. Thanks."
So I give up.
Your Honor, I think the biggest difference is now she's in a much more stable situation with her parents.
And I have stable housing. I have a ride.
So on the dog, hold on. On the dog case, you have a PR now.
Yes. August 27th. Oh, they're pit bulls. They're really cute. They're really friendly. It's not even a big deal. Animal control is just harassing me.
I'm out of her bond. I'll grant. I don't know why. I'm going to grant her my motion. I'll set her bond at a $25,000 personal recognizance bond. Let's make sure you show up.
I'll be here, Your Honor. Thank you so much.
You're welcome.
So I get to go home today?
If you don't have any other holes,
I don't.
go home.
So much.
Huh?
Thank you.
You're more than welcome. All right.
We did.
Hope you enjoyed your vacation.
I did it. I did it. It's been hell. In whole 5 days. It's horrible.
Got to go home now.
Okay.
All right.
Did we get a PCC date, Your Honor? I might have missed it.
I don't know. That was long before the dogs, and then
Thank you.
20th.
The 20th. Okay, not the 27th.
We
Got
got
it.
here, and then she goes and sees the dogs.
Thank you, Your Honor.
You're welcome, ma'am. You have little faith.
That'd be a long day.
Yeah.
It's a lot. Just a lot.
No, no, that was a lot. And, it's like, tell me what time it is. Don't build the clock. Court calls the case, People versus Warren Abbott.
Brian Bowling, Assistant Public Defender on behalf of Mr. Abbott. Oh, great.
Mr. Abbott, could you state your name?
Yes, Warren Abbott.
Your Honor, I'm asking that this matter be set for an examination, please. All discovery is complete.
People have their witnesses available the 18th. August 18th, 2026, 9 a.m. before me.
Perfect. Thanks, Judge.
Court calls the case, People versus Tony Bailey.
People.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Bailey.
Name, sir?
Tony Bailey. How you doing? Good morning, Tony Warren Bailey.
Thank you. All right, what are we doing?
Your Honor, we are requesting a preliminary examination of the matter.
Discovery is complete.
That is my understanding.
People have their witnesses available the 18th.
We're best, Your Honor.
Preliminary examination, August 18th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
All right, bond.
Last day seeing you.
This is?
Yes.
Yeah, you're right, because you'll be before Judge Moore.
You ever look me up on YouTube yet?
Have I looked you up?
Remember, he's a musician.
Yes. I haven't. I try to stay off of YouTube. It doesn't work well.
You on there?
Oh, I do know. All right. Thank you.
Have a nice one, okay?
Take care, Mr. Bailey.
Court calls the case of the People versus Zachariah Haruska Dennis. What did you do?
Kerma Dadush on behalf of Mr. Dennis. Can you please say your name for the record?
Dennis, Your Honor.
All right, he's waiving on all of this.
Yes, Your Honor. He is wishing his right to preliminary examination. Sorry, yeah.
All right. Sir, you're waiving your right to a preliminary examination?
Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed, that you committed.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right?
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts in the 2 cases.
Honor, we do a formal reading of the complaint and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial will be set for
August 17th at 1:30.
August 17th, 2026, 1:30, Judge Hamoud. Bond will continue.
May I purchase any information, Your Honor?
Yes, momentarily.
Thanks, Honor.
Yeah, I did the once. Just something. Court calls the case, People versus Alexis Baker.
Morning, Your Honor. Raymond Cook for the People.
Your Honor, Michelle Hutchins, Assistant Public Defender, on behalf of Alexis Baker. Alexis, please state your name for the record. Alexis Baker. Your Honor, we are setting this for preliminary exam
Discovery is complete.
to the best of my knowledge, yes.
We'll have their witnesses available the 18th.
Do our best, Your Honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
All right.
Bond will continue. Thank you. Court calls case People versus Orby Huffman.
Brian Bowling on behalf of Mr. Huffman. Please, Mr. Huffman.
Orby Huffman.
Okay. That's just one of two. Yeah, it's just one. Yeah. Yes.
Hey, Judge, it's come to my that Mr. Huffman has a case pending before Judge Conlon, and he was referred for a competency evaluation in that case. I believe that happened July 16th. Based on that referral in that matter, I think we need to adjourn this case to wait the.
We can adjourn it. Did you want to do a new referral also on this case?
Yeah, I mean, I guess, yeah, if that's.
I think we should probably do that.
Fair enough.
All right. So, why don't I just put it out 2 weeks, and that way you can get the paper. You can get it here. I'll call it up at that point. We'll do the referral.
Fair enough.
They'll match it up.
Okay. Thanks, Judge.
So I'll adjourn this to August 18th, 2020. No, that was wrong.
20th.
August 20th, 2026, 9 a.m.
And that will be for a probable cause conference. That's what.
Yes.
For,
Okay, I'm setting it for.
I'll get the court in order. Totally.
Okay.
Thanks, Judge.
Mr. Baker, you hand those to the Skinner to sign up. Court does call the case People versus William Baker.
Assistant Public Defender Emzo Hutchins on behalf of William Baker. Mr. Baker, please state your name for the record.
Baker. Last name on. I will allow, I will delete the contact, no contact with Jillian. I'll just do it straight that way.
Thank you.
Okay, thank you.
Oh, Your Honor, I'm sorry. What was the next court date?
27. 27.
August 27th. Thank you.
Court calls case People versus Scott Matthews. What is David's do?
Scott Matthews, let's see.
Scott Matthews. Good morning. This is Public Defender Lauren Perny on behalf of Mr. Matthews. State your name for the record, please.
Scott David Matthews.
Thank you.
You know, Mr. Matthews has cases in 15th District as well. We're seeking an adjournment to see if we can do a global.
What's his next date on the 15th?
Do you remember, Mr. Matthews?
I do not.
Maybe it's the 26th.
I can adjourn it out to the last date I have this month. And
maybe we do the 20th, and if something happens here, that will help 15th too. Does that make sense?
That's the afterwards.
No, that is true. Yeah, maybe do a fall.
The 20th.
Okay.
Okay. I'll adjourn these PCCs to the 20th.
Okay.
Okay.
Thanks.
Hey, you're welcome.
I'll be in.
Court calls case People versus Angela Ball. What is Bellinger do? He's had one case.
Asli Bashir on behalf of Angela Ball.
Her name?
Angela Ball.
Thank you.
And Your Honor, we are requesting an adjournment. An offer has been extended, although we are asking for just a a 2-week adjournment for further negotiation.
August 27th, 2026, 9 a.m.
I'm sorry,
27th?
the 27th?
Yes, ma'am.
Okay, thank you.
All right, you're welcome.
I'm done.
Court calls case People versus Kendrick McBride.
Yeah.
Assistant Public Defender Davy Lieb on behalf of Mr. McBride.
Sir, keep moving up here.
How you doing?
What's your name?
Kendrick Brown McBride.
Thank you.
And I would like to set this matter for preliminary examination. Discovery is complete.
People have their witnesses available the 18th. Preliminary examination, August 18th, 2026, 9 a.m. Yes,
Now, I had went to the emergency room.
pardon?
I went to the emergency room a couple days ago. The doctor said I'm allergic to mold and soy. It's inside the jail, and I'm breaking out every day. And I need help to get this stuff out of my system.
Okay.
See all of this?
So what are you asking for me?
Is there any way that I can get treatment while I'm in custody? Because this is happening every single day. I'm just breaking out all over my body.
Have you asked the folks at the jail, medical at the jail?
Yep, I've been asked.
What did they say?
They just keep giving me third tech and stuff that's not working. Like, I need to get.
Okay, you have to tell them. I'm not a medical person, so I can't tell you. Certainly the public defender's office can make sure that there's communication to the jail regarding your treatment, okay?
And I can reach out to the medical staff.
All right, very good. Thank you.
For the exam.
Judge Moore.
And Your Honor, my apologies. Was that the 18th?
Yes.
Thank you. Thank you very much.
But he was just Bellinger. I was just saying, what? I just don't know what he's doing now. Davy, what's Bellinger doing? He's had only one case.
Just move on line up and I'll.
Okay, all right. I don't know. You sitting at the first seat, you make me nervous. All day I've been nervous. Court calls the case, People versus Anthony Bart.
Your Honor, to the people.
Senior Assistant Public Defender representing Mr. Barton. On Zoom, I know he was having some difficulty earlier.
Mr. Barton? If that's you, Mr. Barton, I can't hear a thing you're saying. You need to unmute.
So where the microphone is, Mr. Barton, that is him. Where the microphone.
That is Mr. Barton?
Yes, I'm
Say that in.
receiving a Teams message from, like I said, he was having trouble. I'm receiving a Teams message.
All right.
Paralegal.
Mr. Barton, hold on a moment. Jeff, don't panic. You're good. All right. Wave your hand if you're Mr. Barton. Where are you driving to? Don't drive. You need to be parked. Oh, he's moving. And
I think he's saying he's not driving. He's showing.
saying you're not driving.
He's showing.
Okay, good. Okay. He's not driving. I got finally.
So
I'm not driving.
He's not driving.
Hold it. Say something again.
I'm here. Can you hear me?
Okay, yeah. Now I hear him. All right.
Okay.
Yay.
Whoa, this has been heck trying to get on here. I've been here 2 hours and something. Trying to get on here all morning. Can't talk to nobody.
Okay.
All right, what are we doing?
Your Honor, we have two things. First, we are requesting an adjournment for ongoing discussions and for discovery. And the second is we'd like to address Mr. Barton's bond. The conditions of his bond. Mr. Barton is a truck driver, which is why you see him in his truck today. He
See in a truck? It looks like a car. You in a truck
Yeah,
or a
I'm in a
car?
truck. I'm in a truck.
You are? That's a
Yes.
short truck. Go ahead.
Okay.
No, I'm just seeing stuff out the side.
It's a
No,
day
go,
cab.
never mind. Go ahead.
Truck driver.
Okay.
And he is concerned because he also is required to test weekly with community corrections. And so, for example, he was asked to test Monday, and for his job, he was in Chicago on Monday and Tuesday driving. So we are asking, and
We'd let him go out of state
so that is
for his work.
that is my understanding.
Let's hope so.
Yes.
All right, go ahead.
So with that, we are asking if and just one more thing, Your Honor, he is required, he is not permitted, excuse me, to use drugs or alcohol because of his job in particular.
Right, because it's a truck driver. I get it.
Yes. So we are asking that the condition that he be required to test deleted from his
How long is he
requirement.
testing?
Not long, Your Honor. I believe he was just arraigned maybe
Four times.
You tested 4 times?
Correct.
They've all
And I've
come
been
back
negative,
clean.
all of them.
Yeah, I got you.
I wouldn't have an objection to removing the testing. I remember when this case was arraigned, I think the reason for the request for testing was just out of concern and safety, because this could have been mental health or substance use related. We weren't
got it.
For that, just to make sure. If he's been testing clean, I think that shows us more of a mental health rather than drug or alcohol related issue.
Understood. Okay, then I will delete that provision. I'll grant your request for bond modification. I'll delete the testing.
Thank you, Your Honor.
All right. Did we give a date already? So then you want this adjourned?
Yes, please.
I'll
Your Honor,
adjourn
can I
it.
speak for one moment?
Sure. Everything's going your way, so you'll probably blow it, but go ahead.
Well, no, I'm not saying nothing crazy.
No, go
so-
ahead. What do you want to say, sir?
In this case, so what's happening is the people that
I
this
think-
whole
No, I
situation happened with.
Hold on, whoa. I got to stop you. I don't want you talking about your case at all.
Oh, no, I was just talking about where they reside. They live 6 doors down from me.
That's okay. That's okay. That's Mr. Barton. Are you?
Your attorney's
I'm
telling
sorry.
you stop.
Okay. All right. I know nothing. My name's Ben.
There
I
you
ain't
go.
in it.
Okay, there you go. Very good. Okay, so I'll set this for September 3rd, 2026, 9 a.m.
Thank you.
All right.
Thank you, Your Honor.
And I've signed an order deleting that condition already.
Thank
All right. Thank you, sir.
Thank you. You
Stay
have a blessed
safe out
day.
there.
Yes, sir. Yes, sir. Have a good one. Bye.
You too.
Court calls the case, People versus David Phelan.
Phelan. I thought you said Phelan.
Not that I know that there's one on the record or anything. So, hi.
He woke you up from your nap.
Oh, come on. Mr. Phelan, can you please state your name for the record?
David Phelan.
And Assistant Public Defender J.F. Bellinger on behalf of Mr. Phelan.
All right.
Your Honor, we are waiving. There is an offer that Mr. Kennedy would like to put on the record for us.
And then counsel, I agree that the bond buying over to me. He's an ad account 4, innovation 2nd, that's back for 7 by 1 for. So we have that worth $3,000, and an ad account 5 of criminal sexual conduct of the 4th. The back code 750.520 E1A, max penalty 2-year and or $500. We have not reached a sentencing agreement, but plan to do so once we're in source 4.
That's our correct understanding of the offer, Your Honor.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
Yeah.
You understand that?
Yes.
Okay. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Thank you, Your Honor. We waive formal reading stand mute at this time. I acknowledge receipt of information.
Defendant. Having waived oral reading, standing mute, court will let her not guilty plea. Pretrial will be set for
August 25th at 1:30 with Judge Conley.
August 25th, 2026, 1:30.
Thank you, Your Honor.
Bond will continue. Thank you.
I'll be in touch with you, okay?
Okay, we're good. Get him signed. Court calls case People versus Stephen Wainwright.
People.
You got court, Wainwright.
System plug center Dr. Lipa for Mr. Wainwright.
Wainwright.
Mr. Wainwright.
Mr. Wainwright. Mr. Wainwright, you got court.
Mr.
All right,
Wainwright.
Wainwright.
It's okay. Officer, you're at his cell, however, correct?
Yes, sir.
All right, thank you. What are we doing?
I'm requesting an adjournment. We do have an independent competency evaluation progress. Our office just received the retainer agreement yesterday for our expert.
For your expert?
Yes.
And how much time are you going to need?
That I don't know. I would ask for 30 days at this point.
All right.
Thank you.
I'll adjourn these out then to September 3rd, 2026, 9 a.m.
Thank you.
Bond will continue. All right.
Thank you.
Pardon? The third. All right, thank you. Thank you, officer. Court does call the case of the People versus Shantia Bonner.
Judge, she just stepped out to use the restroom.
That's a restroom. No, I'm kidding. I'll pass. Hey, ma'am, tell her she doesn't have to run. I'll pass it. All right. She kind of just took off. Court calls the case People versus Francisco Quezada Loretta, actually.
On behalf of Mr. Rivera, Francisco.
And with your name. I can really.
State your
first name.
Francisco Andres Quesada Larreta.
What he said. We're asking for an adjournment. I like how he pronounced it. It didn't sound
But
how he said his name. It didn't sound like it when I said it.
no, it did not.
Oh. We're asking for an adjournment, Your Honor. We want to find out some information on an out-of-county matter.
How much time would you need?
Uh,
I can do 20th, 27th, 3rd.
let's do the third, Judge.
So September.
Adjourn it to September 3rd, 2026, 9 a.m. Bond continue.
Thank you, Judge.
I think you did.
Thank you, sir. Court calls the case of the People versus Garcia Bravo.
Assistant Plug Center Dr. Lipa for Ms. Bravo Garcia.
Bravo. State your name, please.
Jacqueline Bravo Garcia.
All right. I have before me a plea form. Indicates she's going to plead guilty to the charge of failure to return rental property.
Correct, Your Honor. The
1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. Defendant agrees to pay restitution in the amount of $4,879.33. That's the court's full understanding of the agreement.
It is correct, Your Honor.
Please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Jacqueline Bravo Garcia.
All right. You can put your hand.
Okay.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of the offense of failure to return rental property. That
Yes.
is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes, Your Honor.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Did you sign or have cause to be signed an advice of rights form on your behalf?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. You understand you're waiving those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
October 6, 2024, at the location of 2714 Washtenaw Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. Did you rent from a U-Haul there?
Yes, Your Honor.
And was it 2012 Ford Ecoline 20-footer?
Yes.
All right. And there was a point where you were to return that. Is that correct?
Correct.
And did you fail to return that property?
Yes, Your Honor.
And did they make a demand for the return of that and you still did not return it?
Correct.
Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the judge would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be September 10th, 2026, 10 a.m. for Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case People versus Ronald Ray Wilson. 3 cases.
Your Honor.
Sure, again, senior assistant public defender. Ray Wilson.
Mr. Wilson, can you state your name, please?
Wilson.
Thank you. What are we doing?
Your Honor, Ms. Cinda has informed us that there has been some additional investigation and that they intend to add some additional charges, that there is a supplemental report forthcoming from that additional investigation. I've informed my client that we are expecting that should be happening soon, and that in addition, we have been told that there are definitively 4 more warrants that are have been requested and are in the process of being charged. With that information, specifically for the one case where there will be the additional charges, Mr. Wilson is aware that it is my belief where they're going to, or my advice that we have that additional discovery because they can add charges at the preliminary exam. And I would like to see that, or whomever from our office will be representing him would like to have that information and be able to prepare for an exam accordingly. After much discussion, Mr. Wilson is stating that he would prefer to have the preliminary exam set and to exercise his right and to make that request of legal counsel's attorney.
So which case is that?
That is the
Case, I think it's 017 Marvel, open the court that is correct, those potential charges and potential CSC related charges. There are other warrants in the queue that are being reviewed. I believe two aren't. One is malicious destruction of personal property, and I believe one involves an incident in the jail where Mr. Ray Wilson is accused of throwing his feces on correction officers in their face, along with potentially having shake. Those are under review as well. So I do not have those currently charged. And there's further interview that needs to be done with the victim on that 0784 case regarding the potential CSC allegations of verifying her medical records. I think those should be here within 5 years.
So he wants his exam on 0784.
He wants his exam on all three matters, Your Honor. And I have specifically said that I think that we should definitively at least wait on that matter. But given that there are all of these cases, that there may be some benefit to trying to resolve these together as opposed to having them come slowly through the system and keep adding up.
So, sir, you want your exam on these matters?
I just asked to move forward, not to studying up the standards for the staff. I was just asking, so what's the next one is the set for preliminary exam, right?
Well, that would be the next stage, but you got all this other stuff out there. That's what your attorney's indicating. And she'd like to take a look at it, but if you want them set for exam.
I mean, they ain't rearranged me on no other cases yet, so this is the only cases that have been rearranged on. So
Yeah,
I mean, go off of this wish.
The other ones are about to be charged.
Well, I haven't seen the paperwork, or I have not been rearranged on them yet, so.
Okay. So you want exams on these?
Yeah, that's what the next one is set for, right? And we moving forward for the next case, and that's the next one for after this one, right?
Well, that would be the next stage, but your attorney's advising you not to necessarily take that step right now because of these other things that are out there.
I mean, I have not been rearranged on there, Your Honor. So I mean, I don't see the reason.
I know you want to be rearranged. Okay, so here we go. I'll just set him for a preliminary examination. We'll just let it fall where it may. He will not be entitled to an adjournment if there's something there that relates to the case. So
I will note, Your Honor, he's also a mandatory minimum habitual court offender as well.
he's say
Mandatory minimum habitual.
25-year mandatory minimum. All right. Well, he wants to handle it that way. He doesn't want to listen to his attorney. Set preliminary. Would the people have their witnesses available the 18th? Set preliminary examination August 18th, 2026, 9 a.m. before for me. Call me lucky. All right.
Your Honor, if I may approach with Miss Senda briefly.
Yes, you may. Court does call the case, People versus Stephen Lee Schumacher.
And then on behalf of people.
Assistant Public Defender Davi Lebo for Mr. Schumacher.
Your name, sir?
Schumacher.
Thank you.
And a like matter for preliminary examination, please. Discovery is complete.
Do other witnesses available the 18th?
That's your honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. for Judge Moore.
Thank you.
What? Why you? What? What? So you're raising your hand? All my cases are in a line. I called your case. Then next thing you know, she got up running. And then I was going to issue a bench warrant. But then people told me you were coming back. And now you're raising your hand to serve in the court. I could have called 8 cases by now. I'll call you in a minute. You're welcome. Oh boy. I don't know why people are rushing for me to call the case. Court calls the case, People versus Brian Trent.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Brian Trent.
Your Honor, I was just retained in this matter this week. I don't have discovery yet. So
All right.
can we have September 3rd?
Probable cause conference will be adjourned to September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Nope. Court calls case, People versus Natasha Brazelton. I'm gonna make you wait. I had to wait for you to come back.
Council Chair, I can rule you on behalf of Mr. Hazelton.
Oh, talk it slow. She's not going to appear.
I can't talk any slower, Judge. Unfortunately, Your Honor, I have not been able to make contact with Mr. Hazelton. We called and left messages to know if I do not have an explanation for her absence today.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $10,000 cash surety.
Thank you, Judge.
Nope. Court calls the case versus Laura Walter.
People.
Good morning, this is Public Defender Lauren Perny on behalf of Ms. Waldron. Ms. Waldron, state your name for the record, please.
Laura Waldron?
Your Honor, I have 2 requests. One is that
Why kids have one?
I don't know. One is an adjournment. So Ms. Waldron completed some treatment while this case was in warrant status, and I am trying to get proof of that to Ms. Phelps.
Gotcha.
My second request is a release of treatment. I did speak to Ms. Phelps about this. She has some hesitancy due to that warrant status. I suppose I'm now coming to the court for your consideration if that's a possibility. The controlled substance case, I think Ms. Waldron did complete some time at Odyssey House in Saginaw. She is working with, she does have a case manager with DHHS who wants to see her do additional treatment. So she is asking for a release to treatment on this case.
Yeah, this case is originally in 2023, got authorized in 2024. The defendant unfortunately dealt to it later in November 2024, was on her on later. And she was rearranged in November of 2025. After being arranged in November 2025, on December 23rd, she had failed to appear, came late, bench warrant was recalled on that date, and then again failed to appear on January the 15th, 2026. She was here, she had to deal with the kids and then got a ride to get, then had a flat tire, some sort of difficulty there. She was arraigned and said that she had done the treatment. My concern is that we've had 2 days to appear, she's gone for a year.
And I'm just concerned with.
How'd she come back into custody?
She called the police due to a domestic situation. The warrant was pending.
And I think she may have been the victim in that situation. I'm sympathetic to that, but still have.
We still, right. How long an adjournment did you want?
I think Odyssey House said their records person was out yesterday. I think we can get those pretty quickly. I think Ms. Feltus and I are of the similar mind on the resolution of the case, so I have no problem with the 20th. Yeah,
I'll adjourn it out to August 20th, 2026, 9 a.m. I'm going to deny the request for release. Circumstance.
I may file a written bond motion.
I'll read it.
Great. All right, you read it.
Great. Then we can all get together and I can deny it again. No, go ahead.
Just to put y'all on notice, I'm working on some.
That was really country, y'all on notice. Go ahead.
Yeah.
Okay.
I'm not country at all. I don't know.
I know you're not. I don't know where that y'all came from. So that's fine. I mean, if you want to file a written motion, maybe then.
I think there's additional context that the court.
Right. And I may, some of that may come from the records and things you're waiting for. That
Exactly.
I would need to.
Yeah.
Okay. So I certainly will take another look at it. I don't know. Okay.
All right. Thanks.
So at this time, we're about, we'll continue. Court calls the case People versus Michael Brown. Oh, I was gonna call her. No, I wasn't.
System Judge Senator Davila for Mr. Brown. Michael Brown.
Thank you.
And Your Honor, provided Ms. Feltus with some mitigation information, she's going to be reviewing and requesting an adjournment for that to happen.
Turn it to August 27th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Fine, continue. Court recalls the case. People versus Shantia Bonner.
Morning again, Your Honor. Raymond Cook with the people.
This is a recall. Because the first time I called it, she wasn't here.
That's correct.
That's why I'm recalling.
Good afternoon, Judge.
Good afternoon. What's your name?
Santia Bonner.
We knew that. Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Bonner. Your Honor, we have some missing video discovery. I did reach out to APA Cook. Get that information for us, so we asked for an adjournment for that purpose.
And that's the request that I'm hoping I can get in the next few days.
Okay. Who's that with you?
My mother.
Your mother?
Mm-hmm.
She's fast.
Is she?
When I called that case, by the time I got your name out, she's out of that aisle, flying out the door. Bless her heart.
That's my mama.
Yep. Okay. I'll adjourn this then to, why don't I give you till September 3rd, 2026, 9 a.m.
Thank you.
All right.
Judge.
Fine, continue. Not a problem. Mom, take care. Court calls case People versus Melvin Witherspoon.
Assistant Your Honor, on behalf of Mr. Melvin Witherspoon, who's approaching. Mr. Witherspoon, state your name for the record.
Melvin Witherspoon. Yes, sir.
We ask that this matter be set for preliminary exam, Judge.
Discovery is complete.
To our knowledge, it is.
No other witnesses available the 18th. Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
Thank you, Judge.
Bond continued. Dobby, where are you going?
You're welcome.
Oh, okay. See ya. I do that. I know he hates to hear my voice. What was that? Bellinger, stop, just stop. You know what? Taking somebody in today.
I
Huh?
need a vacation.
Volunteer.
I know, right? Thank you for staying at our hotel. Court calls case 3-4 versus Ashley Burke.
That's helps for the people.
It's brick, that's why.
Break? Well, okay. It
It's
was
Bert, good
close.
morning.
It's okay, ma'am. Hold on. I gotta yell at your attorney.
Yeah.
That was your fault. You knew who I was calling.
I didn't.
Didn't?
No.
They paid attention.
I
Everybody else knew.
understood.
And what's your name?
Ashley Burke.
Thank
morning.
you. Good morning. All right, I have before me a plea form. Is that what we're doing?
That is my understanding, Your Honor.
Form indicates that she's going to plead to use of methamphetamine for 1-year offense. Upon her successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is our understanding as well.
Ms. Burke, if you please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Ashley Burke.
All right. You can put your hand down. Ma'am, it is this court's
Okay.
understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, I do.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, it is.
Any question regarding any of those rights?
No.
Looking at paragraph 5, you understand that you're giving up those rights as well as all rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am on probation.
Okay, at the time of this offense, were you on probation?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense, ma'am?
Absolutely, yes.
On the date of June 29, 2023, at the location of 3200 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have methamphetamine or ecstasy in your possession?
I did. I did.
And had you used it?
I was.
And did you know what you were using was methamphetamine or ecstasy?
Yes.
Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, I just I don't want to interrupt, Your Honor. I don't know if my public defender, if he know, I've been in treatment. I'm a 1.5 years clean now from methamphetamines, and I'm still in treatment. I'm in recovery housing. I've been in recovery housing for 1 year now. I'm actually doing pretty good. So I just wanted to state that, Your Honor.
Okay, I remember that from the last time you were before me.
Yeah.
Okay.
Your Honor, I was going to discuss that with the court with regard to the sentencing itself, because I think that she could potentially have a problem getting down to probation over here, since she is still in treatment, but.
Yeah, but we'll, all right.
Cross that bridge.
Okay, where was I? You said they weren't going to interrupt, but they did. I didn't even do that. Okay, see, this is what happened. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court?
Satisfied, Your Honor.
There we go. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be September 9th, 2026, 9 a.m. before me. Bond will continue. What we will do, ma'am, is contact our probation department, much like you're appearing here via Zoom. I'm sure they can do your interview and assessment that way.
Okay.
Okay.
I just have one question, Your Honor. Am I able to have like my probation, if I do get probation, can it run concurrent with my Oakland County case? Because I'm still got a whole year with them. Like I'm on probation for 2 years with them.
Well, here's what'll happen. I'm gonna let my probation officer take a look at that. She'll know. And typically, so that you just understand, you'd have probation here. We're not going to try to duplicate anything that you're already doing. All right.
Okay.
But I'll let them take a close look at that. Okay.
Okay. Yeah.
All right. Thank you, ma'am.
Okay. Thank you, Your Honor. Oh, yeah. September 9th. You guys have a blessed day. Thank you.
Oh, you're welcome. Court calls the case, People versus Jasmine Yates.
On behalf of people, Your Honor.
Assistant Public Defender Hannah Apple appearing.
Rise. Court case is report is now back in session. Admiral J said presiding.
Folks, you're good. You're good. I do appreciate it. Just stay where you are. You may be seated, folks.
Please.
Court does call the case of People versus Cody Wellman. Counsel, state your appearance.
Yes. Is that for me, Your Honor? Or the prosecutor first?
Prosecutor already went.
Oh, okay. Good afternoon, Your Honor. Good afternoon to your staff. May it please the Honorable Report. My name is Thomas Perkins, P 55623, appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name?
Yes, Your Honor. Cody Bowman.
Got it. Okay, what are we doing?
Your Honor, I was awaiting a response. I know that if we could pass this matter for a moment, I did want to reach out to whoever's in the courtroom right now. Or
Perkins, you sound like the clown at a fast food joint. I can't hear you.
Okay. If we could pass for a moment, I'm going to change systems. We could just for a moment. I'll raise my hand when I'm ready.
I don't know what he's. I will pass it. Is that what it was? Thank you. I'm glad you could decipher that. We'll call it back up momentarily, Mr. Perkins. Thank you.
Thank you.
Court calls the case People versus Lisa Keebler, and her attorney is in back dealing with another case, so wait on that. Court calls the case People versus Damon Cooper.
Good afternoon, Your Honor. Did you say that you want defense counsel to place our names on the record without? Okay. Good afternoon. If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Mr. Cooper, will appear by Zoom with the court's permission.
Mr. Cooper?
Yes, Your Honor.
State your name, please.
Damon Cooper.
All right. What are we doing on this case today?
Your Honor, we would like to proceed to exam. I've received the discovery. I have requested additional discovery, but I believe I've gotten pretty much everything that they have available currently.
So you currently have all discovery that you would need?
Yes, I believe so.
All right. People have their witnesses available the 18th. Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
Thank you.
All right. There'll be no adjournment based upon the fact that you didn't have the discovery.
Thank you, Your
Okay?
Honor.
Thank you. Bond continued. Court calls case People versus Kwame Edwards.
On behalf of the people, Your Honor.
Good afternoon, Your Honor. Edward Lucas on behalf of Kwame Edwards.
Your name?
Kwame Edwards.
Thank you, sir.
Your Honor, there's some negotiations still going on. I'd asked for 3 weeks for nothing.
September 3rd work for you?
That would work.
Limit our probable cause conference adjourned September 3rd, 2026, 9 a.m. On continue. Thank you.
Okay.
Court calls case People versus, is it Maccabee? Kaba?
That's the people.
Edward Lucas on behalf of Mr. Kaba, who will be approaching.
Marty Bay Kaba. Thank you.
And I'm also asking for an adjournment, finishing negotiation.
We're going to give you the same date.
Sounds good.
September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus Cameron Harden.
Ashley Phelps for the people.
Good morning. Good afternoon, Judge. On behalf of Mr. Cameron Harden, Attorney Nicholas North, PA 6482. Mr. Harden, please state your full name for the record, sir.
Cameron Harden.
Thank you. What are we doing?
So, Judge, I'm just asking for an adjourned PCC. I do have the discovery. I just need more time to review it.
All right.
Maybe a couple of weeks, please.
20th or 27th, which will work better for you? Don't know why I'm asking.
The 20th works great.
The co-defendant went to the 20th. All right. Probable cause conference, August 20th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Alan Hodge.
Ashley Phelps for the people.
Good afternoon, Judge. On behalf of Mr. Hodge, Attorney Nicholas North, PA 6482. Mr. Hodge, please state your full name for the record, sir.
Do we have him in there?
Hello, I am Alan Hodge.
I lost. State your name again, sir.
Alan Hodge.
Got it. Okay. All right. What are we doing?
Same thing, Judge. I'm just asking for an adjourned PCC so I can have more time to review the discovery. I was just assigned the case this week.
August 20th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Court calls case People versus Timothy James.
Ready, Your Honor. Jacob Kennedy for the people, Your Honor.
Oh,
Your Honor. Thank you. Joe Simon, Mr. James.
no, that was my way of showing pleasure for you being here.
Thank you, Your Honor. Touched my heart. Your name, Timothy James. Your Honor, you should have a green sheet.
I do.
We're going to have my client screened by the 14A4 sobriety court. There's also a referral form that they told me to submit. I don't know if that's written for Your Honor to submit, your court staff to submit it, but I'll submit it if that's the right thing. But anyway, asking to adjourn. Say that again. There's a referral form they ask us to fill out, really for your honor staff to submit it to them. But
Correct.
Okay, so that's all I just wanted.
Should get over to them.
All right, so that's what I was just verifying. But anyway,
right. That's what I think.
That's
not my staff.
Then all right. Then we happy to have that happen. That form says 2 weeks, but in my experience, Your Honor, can we have about 4 weeks to adjourn the PCC for that evaluation and come back?
Why are you nodding?
I'm in total agreement. In my experience, it also takes by much less years in experience.
Wow.
Hurtful, but
Simon,
hurtful but fair. Hurtful but fair. I can't say.
Oh, no, that was like, I'm calling you really old. Like,
Can't say.
much less experienced.
Can't say anything.
Kennedy's going to get himself in trouble. Probable cause conference, September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
I don't care about you, Ken. I mean, you're welcome.
Right.
Court does call the case, People versus Stephen Klein.
The people.
And Judge, good afternoon. Vincent Haysha with and on behalf of Mr. Klein, who's present on Zoom. No objection to that.
Mr. Klein, can you state your name, please? Oh, there he is. You have to unmute. I see your lips moving, but.
I apologize, Your Honor. Stephen Klein.
Okay, no apology necessary. All right, what are we doing?
Judge, if I could, I spoke to Mr. Cook. We have an offer that will be reduced to a misdemeanor. However, I did just get the digital discovery. If we could set for a PCC on the 20th, if the court's available, I suspect it'll be a plea. But if it is, we'll obviously be in person. And if it isn't, then we'll set for an exam. But I don't think we need to set for exam at this point.
They just needed it the 20th?
20th would be fine, unless if it's going to be a plea, Judge, would the 20th be a date that we can keep for that, or will that date change?
Say that again.
If it results in a plea, could we plea on the 20th, or would that be?
Oh yeah, absolutely.
Okay, I can make the 20th work.
That will not be a date we can take testimony. So if you're looking for an exam date, we have to get a different.
No, just a PCC.
No, he just wants to make sure we can plea at that time. Yeah, absolutely, counsel. So I'll adjourn it to August 20th, 2026, 9 a.m.
Excellent, Judge. Thank you. Yep.
Court calls the case, People versus Patrick Lay.
Good afternoon, Your Honor. Raymond.
Good afternoon, Your Honor. Michael Vincent on behalf of Patrick Lay.
Good afternoon, Mr. Vincent. How are you, sir?
Old.
Okay.
Older than Simon.
Older than Simon, yes. All right. They really let you travel alone. Nobody's here from your office.
Everyone's gone. Ellie's getting married tomorrow. I'm here all by myself.
Oh, boy. Okay.
There was agreement, I believe.
My understanding is the defendants paid back the restitution on this case based in consultation with the victims who would be dismissed.
Accept it.
No objection.
No.
Case is dismissed.
I'm in for Mr. Goldstein on a Javon Mills. And he just needs a prelim date. If I could do that one also, because I'm old. Remember, I'm old.
So, Mr. Vincent, when have you ever walked in here and been able to call your own case?
How much time do I have to try to? It was suggested.
Let's call it for the.
It was suggested.
Wait. Is this that? Only you.
Thank you.
And it will never happen again. Court calls the case, People versus Javon Mills.
Then on behalf of Your Honor.
The Mills?
Seriously?
Mills?
No, he's right here.
Michael Vincent, standing in for David Goldstein on Javon Mills. Step forward, state your name, sir.
Go ahead. All right. You have no objection to Mr. Vincent stepping in for this?
No, sir.
Thank you.
David asked for a prelim exam on dates 8/25 or 9/1.
You know,
it's not me demanding.
No, I told somebody earlier today, I have no qualms about shooting the messenger. I
have a lot of qualms about dying.
Is discovery complete?
My understanding, yes.
Will the people have their witness? I don't know why I allow this. Will people have their witnesses available the 25th? How Goldstein went up on my list too. Set preliminary examination, August 25th, 2026, 9 a.m. for Judge
Washington.
Judge Washington.
All right, thank you. Make sure you call David up, okay?
Court calls the case, People versus Gerald Barhofer. All right. Like who isn't?
Good afternoon, Your Honor. Deanna Kelly appearing on behalf of Mr. Marhofer. He's present to my right. Could you state your name?
Gerald Marhofer.
Thank you. Your Honor, we are respectfully requesting a short adjournment. The prosecutor and I are engaging in conversation that might result in a resolution.
27th of the 3rd. I don't know why I'm being so nice. Go ahead.
We're always nice and I appreciate that. And we would
Wow.
love to come back and
better about me.
we would come back and see you on the 27th.
27.
Yes.
DCC will be adjourned August 27th, 2020.
Thank you, Judge.
Thank you. Bond continued. Court calls case People versus Teresa Heichel.
Good morning, Your Honor. Marcia Crater on behalf of Mr. Heichel, who's on Zoom by permission. Ma'am, can you please state your name?
Teresa Heichel.
Thank you.
Your Honor, discovery is not complete. We're asking for a 2-week adjournment for 911 calls.
August 27th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case People versus Matthew Moy.
Your Honor.
And so this is all 12:30.
Yeah. 149.
Did good, relatively good this morning.
Good afternoon, Your Honor. Marcia Crater on behalf of Mr. Moy. Sir, can you please state your name?
Matthew Thomas Moy.
How you doing, Mr. Moore?
Pretty good, Your Honor. You?
Trying. All right. I have before me a plea form that indicates the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer. The 1-year offense. Upon a successful plea to that added count 2, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor. That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Lower your hand. State your first and last name and record.
Matthew Moy.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yep.
Question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I am.
Were you on probation at the time of this offense?
Yes, Your Honor.
Then I have to advise you that your guilty plea in this case could be considered a violation of that probation. You understand that?
Yes, Your Honor.
Is considered a violation. The judge in the other case could sentence you to the maximum allowable under the other charge or charges. You understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
February 18, 2026, at the location of Packard near Thompson Street, City of Ann Arbor, Washington County, State of Michigan. Did you come into contact with University of Michigan Police Department officers?
Yes.
What happened?
I was pulled over. I think I gave them my ID. They went back to run my name, and I exited the vehicle and tried to run, Your Honor. made it to the fence. When I realized that there was another fence behind it and a tree and there were police officers behind me, I just surrendered, but I did run.
Didn't work. No, it didn't. Yeah. Nope. All right. And you realized they were in the performance of their lawful duties.
Yes, Your Honor.
Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Do you understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements led to this plea?
I'm not, Your Honor. Thank you.
Defense is not, Your Honor.
And have I complied with the court?
Floor satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation is ordered at 15th District Court probation. Sentencing will be
August 28th at 8:30.
August 28, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Razan did it. Court calls the case People versus Mikey Nunn.
Your Honor, Raymond Cook for the people.
Good afternoon, Your Honor. Robin McCoy, P63057, appearing on behalf of Mackay Nunn.
Okay, got the name wrong. I get it. All right. Nunn, can you state your name, please?
Good morning, Your Honor. My name is Mackay Nunn.
Please.
Oh, I'm sorry.
Right.
Afternoon.
It's okay. No, we're good. All right. What are we doing?
Well, we have been talking with the prosecutor about working on a potential resolution. I had the understanding that there was a video, but we've been emailing about and making the request. We haven't seen the video yet. We'd be asking for an adjourned PCC, and we also did. His mom is present via Zoom. We want to address the bond as well.
Probable cause conference will be adjourned August 27, 2026, 9 a.m. As to bond.
Okay, Your Honor, as of right now, he is under house arrest. But we emailed the prosecutor. We wanted to update the court. He is seeing a therapist. He has applied to school and he has job prospects. I spoke with his mother, he and his mother yesterday. They're asking if the bond could be modified so that he could have a tether and that he no longer be under house arrest. They said that one of the jobs prospects would be he would be working with a relative and under their supervision.
Response.
I know Your Honor's already familiar with the circumstances of this case and of this defendant. I think if we could get definitive dates and times that he would be working in a location, I'd have no issue with an exception for those carve outs. I'd just like to make sure that we have firm plan in place before just releasing the house arrest in its entirety.
And I would agree with the people on that. I don't have a problem making exceptions, but I will not just give carte blanche regarding this tether.
Okay, and then I just want to be clear. So you want definitive times for his work schedule and for his school schedule?
Yes.
Okay, we can get that.
All right, get that over to the prosecutor. It sounds like there would be agreement, and then you guys just prepare an order and we're good. All right. Okay. In all other respects, bond will continue.
Today's courtroom session took several unexpected turns, with defendants facing everything from preliminary examinations and bond decisions to competency issues, plea negotiations, and emotional courtroom moments. At the beginning of this portion of the hearing, the court moved through case after case, dealing with scheduling issues, missing discovery, and requests for additional time. In the case of Donald Baker, the defense requested a preliminary examination, but the court learned that additional video evidence still needed to be obtained. The examination was ultimately scheduled for September 1st, giving the attorneys time to address the missing material. The hearing continued with several defendants whose cases were delayed because attorneys had not yet been able to meet with their clients. In multiple cases, the judge granted short adjournments so lawyers could review discovery, speak with their clients, or continue negotiations. But one of the most serious moments came when the court addressed a competency issue involving Renee Williams. Her attorney explained that she was in California and that additional time